Hello, this is Matt on the Moon Lambo channel. Attorney John Deaton, who is the attorney who is seeking to intervene in the SEC versus Ripple case on behalf of over 17,000 XRP holders, has confirmed that the SEC has given more ammo to Ripple. The SEC has strengthened Ripple's legal position. And so this has to do with this article that's on your screen right now, and I covered it a couple days ago when it hit the scene. But it was titled "In the Matter of Coin Schedule," and so I'm not going to go through the whole thing again, but a couple points that you do need to know just to make sure I properly set the table here. This was written by two commissioners, Hester Peirce and Elad Roisman, and they really laid out the case for why there's not sufficient regulatory clarity, and market participants in the United States have a tough time figuring out if the SEC thinks that a cryptocurrency, just pick whatever your cryptocurrency is a security or is not a security. And they also cited that what's been happening now is, as a result of the lack of regulatory clarity, is that the SEC's effectively doing what we've been saying on this on this channel, in the XRP community, frankly, ever since this all started, which is that the SEC is regulating through enforcement, which is a despicable way to move forward. It's like, don't let people know if they're doing something wrong, but if they do and you don't like something that they do, then you're going to throw the hammer at them and say, you should have known what you're doing was wrong all along, even though the SEC didn't know. And so I love the intellectual honesty coming from these two, Hester and Elad. And so when going through this a couple days ago, I said, look, I don't have a legal background. I was like, I don't know what the legal implications of this. I don't know if this could have an impact on the Ripple case. But I said, as the layperson sitting here reading this, I said, if you have half a brain and you read this, you could see that this just shreds the SEC's case. Because the SEC, they insist that Ripple did have fair notice. Ripple says, no, we didn't have fair notice that what we were doing is wrong. You're making up the rules after the fact, effectively, which, by the way, they can't do. And so if Ripple didn't have fair notice that what they were doing was illegal, then they cannot be found to have been in the wrong here. And that's how it works by law. I've been following a number of attorneys within the XRP community, and they made it very clear that it is the case that this is over. If Ripple's fair notice defense ends up standing, that's it. It's over. You cannot go after somebody in court claiming they should have done something different if you're the SEC when you didn't. Because basically what you're doing at this point is you're retroactively going back, like you're creating laws after something was done, but it wasn't illegal when they did it. It's kind of like that. It's just as bad, right? And so his question is so is there a chance that this is actually going to hurt the SEC? And it looks like the answer is yes. So I'm going to share with you the specifics, but yeah, I'm happy to share that. I don't want to tease it right here at the outset of the video. Absolutely. Now, again, I don't have a legal background of any kind. I also do not have a financial background of any kind. And so I'm not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who likes making YouTube videos as a hobby. And so here was this tweet from attorney John Deaton, and he wrote the following. 2 years ago, the UK's Financial Conduct Authority, or FCA for short, established digital assets into three categories. Number 1, exchange tokens. Number 2, utility tokens. And 3, security tokens. XRP is considered a hybrid token falling between a utility and exchange token. And so the UK said, no, XRP, of course, not a security. That designation is unique within the United States. And so there we are. And then he said, meantime, in the U.S., the SEC continues to ... And then he didn't finish. So I don't know for sure if he intended to continue that thread or if his organization Crypto Law, which he founded, jumped in and finished it, and then he decided not to go back. Or maybe he may have just intended to leave it at the 5 dots right there. But Crypto Law, which is an entity which is, if you're not familiar, what's their website? Crypto-law.us, I think, is the website. Either you can find them on Twitter too at Crypto Law US. And so they jumped in, and so again, the first part of the sentence, meantime, in the U.S., the SEC continues to ... and Crypto Law finished the sentence. Show reluctance to provide additional guidance about how to determine whether a token is being sold as part of a securities offering or which tokens are securities. Now, so not only did that perfectly finish the sentence, that also happens to be, as is cited in this tweet, a quote from SEC commissioners Hester and Elad from this piece that I covered a couple days ago. I think it's in maybe the second paragraph. Yeah, here it is. It's in the second paragraph. They wrote, "We nevertheless are disappointed that the Commission's settlement with CoinSchedule did not explain which digital assets touted by CoinSchedule were securities, an omission which is symptomatic of our reluctance to provide additional guidance about how to determine whether a token is being sold as part of a securities offering or which tokens are securities." Exactly. So the first time I read that, I was like, oh man, I cannot imagine that your coworkers like you guys very much. Now, I like them. I think it's incredible what they're doing here, but there's got to be some really not so happy attorneys at the SEC that are participating in this case. And they're like, okay, well, thanks for nothing. That's probably what they're thinking. But it's true. They're doing what's right. This is respectable, And so then John Deaton, and this is where this is to me the most interesting thing about this particular topic on this case. John Deaton went ahead and retweeted that from Crypto Law, that quote, and he wrote the following: "Leave it to Crypto Law to finish the sentence I posed by quoting 2 of the 5 commissioners appointed to the SEC." And then he wrote, under evidence law, this is called an admission by party opponent. I'm sure the litigation team at the SEC isn't happy with Hester and Elad. There you go. And so actually there are legal implications of this, it seems. Because again, he wrote, under evidence law, this is called an admission by party opponent. So think about this, because I get it. So Hester is in a different part of the SEC than the lawyers, but they're part of the same organization, and they're at odds against each other. The lawyers say, nope, there's fair notice, everything's crystal clear. But then you have Hester Peirce, which is one of the 5, and Elad, so 2 of the 5 commissioners that actually vote on whether or not to bring actions against entities, saying there's really not sufficient clarity, actually. So I'd be willing to bet that the way they vote, right? I think don't know for sure, but still. And then there was this from an XRP community member named Alan. I just came across this and it resonated with me, so I wanted to share this with you. Miss Peirce is carving out a small piece of financial history for herself. I do believe she comes out on the right side of this, not because it's what we want, but because she's taking a practical approach to the industry. You can't allow people to build multi-billion-dollar businesses and then pull the rug out after many years. There has to be a practical approach. It would be completely different if there was a fraudulent intentions, but there's not. The SEC is suing on technicalities based on an Orange Grove case from 1933, 76 years before crypto. Am I mistaken? I thought it was 1946. Maybe I'm wrong. I could be wrong. I'd have to Google that real quick. That sounds like a lot of work, though. I'm not going to do it right now. And then there was this from somebody named Neatsbucks. I like this one, too. Simply wrote, if Hinman truly gave a speech unendorsed by the SEC, why didn't they fire him or immediately clarify that this was his personal view? At a normal job, you are held accountable for your actions. Yeah, and that's a perfectly good point, which I brought up before, too. I think it was worded quite well here. But the truth is that was intended to be the SEC's official position. William Hinman was just the vessel through which this information was communicated. That's all it was. Now they're pretending that's not the case. But if it weren't the case, then back then, this would have been a big deal. Like, whoa. People are going to think, William, Billy, oh boy, what are you doing here? People are going to think that this is our official position. Something would have been done. There would have been clarification. That clearly didn't happen. And the whole world took that as purely being the official green light from the SEC, and the officials at the SEC knew that, and now they're pretending that's not the case. Liars. These are bad people. These are not good people. Really grinds my gears, folks. Really grinds my gears. Now let's jump into this, because this is fun here. SEC versus Ripple. SEC is desperate for this deposition not to go forward. Desperate. You gotta love this here. That's the headline from Finance Feeds. Ripple has scored a major win yesterday with the court ordering the deposition of ex-SEC Director William Hinman. The exceptional circumstances that allow for the deposition of a high-ranking officer are the uniqueness of the lawsuit and the extraordinary public interest. On the side of the agency was a new counsel, Miss Stewart, instead of Jorge Tenrero, who has been leading the plaintiff's arguments. Miss Stewart was the one who had to explain to the judge why the SEC says privilege would be breached if the scheduled deposition is about a public speech based on William Hinman's personal views and not on behalf of the SEC. Privileged as deliberative, she answered, adding that the deliberative process privilege would be invoked if Hinman was deposed. Now, when Judge Sarah Knepern ruled to allow for the deposition on Monday, the SEC said it would, quote, need time to evaluate that, end quote. And here's another quote. So this is from attorney Jeremy Hogan. This is why I wanted to highlight this. I love this quote. This is good. Actually, I got a couple, though. I think I like the next one even better. Let me read this one first, though. That can mean only one thing. Absent an agreement between the parties, the SEC intends to appeal the ruling allowing the deposition to go forward, and it's almost never done. And here's the one, I like this one even more. Even thinking about appealing this order suggests to me that the SEC is desperate for this deposition not to go forward. Desperate. Why exactly they are desperate, I do not know. But there is something there that is not just normal, but a normal bad for them, but really, really bad for them. And so that's the thing, though. And Jeremy had pointed this out as well. It's during the deposition, if there's something really, really bad that's being hidden here, will Ripple's team of lawyers be able to even ask the right question to potentially elicit the response? And even if they do, like if they do ask the right question to get at the really, really bad secret that it seems clear the SEC doesn't want out, is Hinman going to answer? He is going to be under oath, so he can't lie. But you can be slippery with words. I mean, we all know that. So is the truth going to be made known? Either way, the SEC clearly sees this as a tremendous risk to their case here. And the more details come out, the worse it looks for the SEC day after day after day. They are not right. They will be proven to be on the wrong side of the law. Even if there's a settlement and they claim victory, woo, whoops-a-doodles. Well, you know what? The history books, if written by unbiased individuals, are going to view this all as a win for Ripple and XRP. So you say what you want, classify it how you want, SEC, even if that happens. But you're on the wrong side of this. You're unethical and you are illogical, and that's just the case. That's just the state of things right now. Man. I think I got one more thing before wrapping up here. Here we go. Yeah, this is just an interesting question. This comes from XRP Researcher on Twitter. And XRP Researcher tagged Jeremy Hogan and John Deaton, attorneys within the XRP community. And John XRP Researcher asked, since Hinman doesn't work for the SEC anymore, does he need to call a lawyer to protect himself, to know his rights of what he should and should not answer, or does the SEC still protect him since he made the statements while he worked for them? And then John Deaton responded as follows. He will have a private lawyer with him or a team at the deposition. The SEC attorney will instruct him not to answer questions when the SEC claims it's privilege. His private lawyers will also object and run interference. I would seek a special master to preside over it. And then attorney James Filan jumped in, and I actually just noticed this. I haven't read this tweet yet, but let's see what he had to say. He's an attorney within the XRP community, and he said, it's a privilege unique to the government, unlike the attorney-client privilege, so the SEC owns and will invoke the privilege. There you go. All right, interesting stuff all around, but it turns out, again, I love that this is the case. What Hester and Elad said, while being intellectually honest and doing the right thing, it does damage, from a legal perspective, the case of the SEC versus Ripple. Good. I absolutely, and they know what they're doing. They are well aware of what they're doing. So, think of that what you will. That's why I like when I'm sitting here thinking, okay, how do you think Hester Peirce voted? To bring the complaint against Ripple or to not bring the complaint against Ripple? I'm going to guess no, and we will find out once this is all said and done. That's just how this works, but we don't find out until either there's a settlement or full adjudication of the case. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.